Good morning, everybody. I'd start with a little, and this might help us, a little basic admin before we get going. We've got a chat panel on the right-hand side of your screen, and we'd welcome any questions that you have or want to ask as we go through the webinar. And at the end of that, we will be able to ask those to the expert panel if they haven't already answered those questions. So that's the first thing. Please use the chat panel for any questions you've got, and we will get to them. Also, we would welcome your thoughts and ideas. There'll be a questionnaire that we send after the webinar is finished today, and we'd love to have any of your thoughts, any of your questions, hopefully constructive criticism. We hope this goes well today, but any thoughts on future webinars or seminars, we're keen to be very topical, on point, relevant. So anything you think you'd like to hear about, we'd love to hear about too. So I will start, or I'll get moving now. Brilliant. Welcome, everybody. I'm Luke Salmon. I'm a director at Michael Page, and I work in our specialist HR recruitment division. And I've run a number of seminars and webinars such as these with my colleagues. We've got a number of HR colleagues across the country with a number of clients in the HR management fields, HR professionals that are keen to hear about relevant information. What we've done is we've come up with a couple of webinars that we thought would be very topical right now. We called it Unlocking the Lockdown because we realised that coming out of the lockdown would be a lot more complicated than going in. And we had one about 3 weeks ago, which was Unlocking the Lockdown Part 1. It was a brilliant webinar, and it was all about health and safety. And it was about bringing the workforce back to the workplace. And we had experts from Pret a Manger, the health and safety, head of health and safety. We had an expert from Squire Patton Boggs on health and safety. And we had Michael Page's very own facilities manager who manages all our offices across Europe to talk about bringing people back to the workplace, anecdotes, ideas. And if you didn't see that and you'd like to see that, then please let us know. But we've got a recording of that webinar. Today, we thought we'd come to Unlocking the Lockdown Part 2. And on this webinar, we thought we'd talk about key people questions that those HR professionals or management teams are being faced with, some for the first time coming out of lockdown. We realise it's very complicated. So I'm very happy to be joined today by two experts from UK and international law firm Squire Patton Boggs. And when it comes to answering questions about employment law or business immigration for businesses, these guys really know their stuff. So welcome, Miriam and Supinder. Good morning, guys. How are you?
Very well, thank you.
Good to have you on board, Miriam, Supinder. Thank you for joining us. I'll let them speak more soon. Their resumes are in front of you, but I think what's most important to say is we're very lucky, as well as being experts and partners in employment law and business immigration. They're also very, very close to everything that's going on. Miriam and Supinder run a range of seminars across the South with Michael Page, where they're constantly briefing HR professionals and management teams on relevant topics within HR. And most recently, they're very much moving with the times. And as soon as this started, I know Miriam and Supinder and Michael Page put together some virtual coffee mornings where Miriam and Supinder sit with HR executives, senior HR professionals, and talk about, share questions and answers to current issues or problems. So hopefully they'll be very close to the questions and concerns that you on the webinar might have today. So no pressure, Miriam or Supinder, but hopefully you guys will know exactly what everyone's thinking. So why this webinar? And this is a brief explanation of why we're doing it. I explained that we wanted to do something very relevant. So I've looked at the headlines in the last week and I've put some up. And what we're very aware of is that this crisis continues to throw up more and more challenges for businesses. And as you can see on there, they range from commercial decisions companies are going to have to make, such as job cuts or the economic bounce back not coming back as quickly as we thought, right through to the new issues that your employees are likely to voice and question, which are just as important. And as we can see there, some headlines, I'm not very happy going back to work, it's too soon, or workers should not return to unsafe workplaces. So we at Michael Page wanted to see if we could help you begin to address them, and that's why we brought this panel together and this series of webinars. So the agenda, before we move on, and this will be me finishing talking and moving on to the experts, you'll be glad to hear. The agenda would be to hear from Miriam Lampert, who's a partner and an expert in employment law, and she'll talk about the questions she's hearing or some of the issues. and then we'll move on to Supinder Sian, and he'll talk about business immigration, bringing your workers into the country or sending them out of the country. And after that, we'll have a Q&A session, and all the questions that you're putting in the questions box in the questions panel, the chat panel, we'll be able to relay to the panel of experts. So we're going to kick off first. We've got a couple of polls that we can use, and it'd be very useful to see your answers to them. It'll help the expert panel understand our audience. So I will hand over to Miriam, and she will crack on with the first poll, which I think should be in front of you now.
Thanks, Luke. Morning, everybody. Thanks so much for joining. So the first poll that we would just like to get your views on is this. So in terms of your workforce currently, we'd like to know whether the majority of your workforce is currently working from home, working from an office or a production facility or retail outlet, obviously, or working on a mixture of the two. So some working from home and some back in the workplace. So I can just ask you to just quickly vote on that. We'll just give it a few seconds, and then we'll see the answers to the poll. So, right, well, that's interesting. 71% of you have currently got the majority of your workforce working from home, 5% working in an office or production facility or retail outlet, and then 24% have a mixture of the two. So clearly the issue of returning into the workplace is really a burning issue for very much the majority of you. So moving on to the next question. So can we just move on to the next slide, please? Thanks. So the next poll, for those of you that do currently have your workforce working remotely, when are you proposing to bring or start bringing them back into the workspace? So July, August, September, or October? And I appreciate there may be some of you that it's none of the above, in which case I apologise, you can't vote. And the results are, so this is really interesting, a very broad split. So 27% are saying that they're going to bring back people in July, 17% in August, 43% in September, and 14% in October. So that's interesting. When September is obviously when hopefully the majority of the schools will be back, but we'll touch on that shortly. So thank you for that. That's really helpful for me, and hopefully useful to get a view of where things stand. So I'm going to move on now and then just talk through some of the very, very large number of questions that we're talking about our clients with at the moment. This really is just a snapshot. There are so many issues that you as HR professionals and us as employment lawyers are grappling with at the moment, but these are the ones that I guess are probably we're being asked the most frequently at the moment. So obviously, in terms of bringing people back to the workplace, there is then the issue of how you should select which staff to bring back first. Now, clearly, the overriding driver there is business need. Who do you need back in the workplace? The government guidance at the moment is work from home if you can. That will obviously change over time. Your decision-making process as to who you bring back and when will be driven by business need and also by health and safety limitations. And I know that obviously these were discussed in detail on the webinar that was that Luke mentioned that happened about 3 weeks ago. So I won't go in detail about the health and safety limitations, but I think everybody appreciates that there are going to be, for many, many businesses, restrictions on the number of people that can actually be in the workplace at the same time. So there's really a kind of an information gathering process that needs to go on, and if you haven't already started doing this, and I'm sure by far the majority of you have, you should be doing this now. And it's partly information gathering at your end, but also talking to your staff as well. So in terms of from the business side, it's about identifying which roles really need to be performed in the office, and thinking about, again, how many staff you can safely have in the office at any one time or in the business premises at any one time. And then thinking about how many of each role you will need back. It's very important that when thinking about that, you also bear in mind that you're going to need to have sufficient number of supervisory, managerial people around to make sure that work is not only carried out properly, but safely. So if you have people, you're going to need people on site at all times who are sufficiently aware of the health and safety restraints and requirements to make sure that work is carried out safely. Where you're looking at bringing back a smaller number of people from within a group of people, you need to be mindful of ensuring that you're selecting people in a fair manner to avoid allegations that you've made decisions on discriminatory grounds. One would assume that, particularly given how challenging the business environment is at the moment, you will be looking to bring your best people back first, obviously personal circumstances accepted. And I certainly know from talking to a number of our clients that really the decisions they're taking now in terms of who they're going to bring back are a kind of a precursor to redundancy processes. So the people they're not bringing back are likely to be the ones who are going to be put at risk of redundancy. And if you're in that kind of position, then you do really need to be doing some kind of almost in reverse redundancy selection process. Now, obviously, I'm not saying, you know, go to the nth degree, and you certainly wouldn't be sharing those criteria with staff. But if you need to be in a position that you can explain, justify decisions if necessary in the future, particularly if it does transpire that the ones that you don't bring back are the ones that are put at risk of redundancy. So just bear that in mind. As I mentioned, there are obviously two aspects to this. There's both the business side and employee side in terms of information gathering. Certainly what we're seeing, and we've done this within our own firm very recently, is our clients are going out to staff, sending out surveys to gather information to understand any specific issues or concerns that employees have. So, for example, are they at a higher health risk? Are they clinically extremely vulnerable or vulnerable? Are they having childcare challenges? How will they be travelling to work? For those of you that are based in major urban areas with staff that are predominantly travelling into work on public transport, that is clearly an issue, a concern. You could also obviously ask people whether they would like to be amongst the first group of people that come back to work. Now, as with any kind of volunteering situation, you're never bound by it. It's never ideal to be in a situation that you're forcing people back into work with a gun to their head. But I do think it's important that people understand when they're saying they want to come back to work that the workplace as we know it is going to be very, very different. So that's your kind of initial information gathering exercise, and you should be making your decisions having gathered that information. So moving on then to the next issue. When you've gathered that information and you've made your decisions about who ideally you would like to come to work, the next big area of challenge that our clients are facing is what they should be doing about employees who can't return to work. Now, I guess broadly speaking, these break down into 2-3 buckets. The first is working parents. Second is people who are living with extremely vulnerable family members. And the third are those who are self-isolating or shielding. I guess that breaks down actually further into people who are clinically vulnerable and clinically extremely vulnerable. And I'll come back to that in a minute. So in relation to working parents, I read with somewhat despair as the mother of 2 children, the fact that not only is it unlikely now that primary school children will be back potentially by the end of this school year, but you know they're now suggesting that secondary school children may be pushed back at some point, you know, past September. So we have this ongoing challenge of working parents who have children at home who need childcare. We don't know what's going to be happening in terms of childcare provision over the summer, and may not be able to come back to work for some period of time. And you then have the people who are living with extremely vulnerable family members who themselves are capable of coming to work but are nervous about coming back because of the risks to their family members. And broadly speaking, from a legal perspective, the way that you treat them is quite similar. Obviously, if they can work from home, you should allow that. There's no doubt about that. It's very important to speak to the employees to understand what their personal position is. Somebody said to me yesterday, well, I know that one of my employees, okay, they're working, but I know that their partner isn't. So why can't their partner just look after their child? Why am I having to deal with this? And I mean, I can understand that argument, but again, you don't know what the nuances are, and it may be that there are reasons why that isn't possible. But I think it's certainly fine to have a dialogue with your employees about this issue, though clearly in a sensitive and tactful manner. But if you get to the point where you just literally, it is not possible to find a way for them to come back to work, and they can't work from home, then we go back to the existing mechanisms that existed in employment law pre-COVID, and it's hard to imagine there was a world pre-COVID now, but what you're looking at then is potentially agreeing that they'll take an extended period of unpaid leave, changing their working hours, so perhaps working first thing in the morning, last thing at the end of the day. I'm sure that is already something that many of you have been doing with your working parents anyway over the last few months. Potentially agreeing parental leave, again, that would be unpaid, or offering the opportunity for them to take annual leave entitlement. I mean, that's fine as a short-term solution, but that will very quickly get used up. So would really only be there to help them financially in between other periods of unpaid leave. Remember also that the government guidance has clearly stated that people who are unable to work because of these, because they're working parents or and the like, they are eligible to be furloughed. But as I'm sure you know, and we'll talk about it in a minute, obviously the furlough scheme is changing, and they will need to have been furloughed for a period of 3 weeks by the 30th of June 2020. One kind of piece of breaking news related to that, some of you may have seen that last night the government announced that employees returning from the various different types of family-friendly leave, so paternity, maternity, adoption, shared parental leave, and parental bereavement leave, are all going to be allowed to be furloughed, even if they missed the 3-week furlough requirement by the 30th of June. So if they come back from maternity leave, for example, in 2 months' time, they can still be furloughed, even if they haven't been furloughed before, provided their employer has previously furloughed other employees. So that's important and right and fair that these people aren't missing out because they've been on family-friendly leaves. The other category of employees is self-isolating or shielding employees, and again, the government guidances allow them to work from home if possible. As things progress, we're going to see a more nuanced approach depending upon whether or not somebody is clinically vulnerable or clinically extremely vulnerable. And if you want to see further information about how people break down into that, start with the workplace guidelines issued by the government, because they lead you to the various different descriptions of who falls into which category. But broadly speaking, what the workplace guidelines are saying is clinically extremely vulnerable people are strongly advised not to work outside the home, whereas clinically vulnerable people are not precluded from coming into work, but you still need to treat them with care, and ideally you put them in a position, you try to find a role for them in the workplace which reduces the risk so far as possible. So I mean, I think it's quite a complex area, and one for more discussion if we have more time. But broadly speaking, the government has made clear at the moment that employees that fall within these categories will be entitled to SSP and should be treated in the same way as sick employees. And they've also made clear that if somebody is required to self-isolate because they've been contacted through the track and trace system, they will also be entitled to SSP. I mean, I think this is a holding pattern situation, because we don't know how long this situation is going to last. And there will come a point in time, not yet, when employers are going to start saying, I have employees who cannot come into work, they can't work from home. It is no longer viable for me just to have them sitting there on the books. I think this will probably come once the SSP is exhausted. And at that point, you may need to start looking at potentially exiting them from the business in the same way that you would with someone with long-term sickness. But I wouldn't be advocating doing that at the moment. And I think there are huge PR risks actually of doing it at the moment. But it is unfortunately going to be a reality if we don't manage to find vaccines and effective treatments, within the kind of medium term. So that's the employees who can't return to work. Moving on, we're looking at those what do we do about the employees who won't return to work? So there's no medical issue preventing them coming from work. They're not coming back to work. They're not working parents, but they are understandably, like many of us, nervous about coming back to work and travelling to work. I mean, I live in London. The thought of getting on the crowded Northern Line doesn't, it's worrying. So it's entirely understandable that people are worried about coming back to work, but it doesn't mean that they can flat refuse to come to work. I think there is a practical issues here and there's some legal issues here. The practical issues here is a lot of this is psychological. People are very, very worried, and the more that you can do to communicate with staff, to reassure them about the steps that you are putting in place to protect their health and safety, the greater the chances are that you will manage to get people back into work. So communication is absolutely key. Obviously, there's lots of different ways that you can communicate. Email updates, blogs, and the like. One thing I would say, which I saw through my daughter's school, actually, they produced a video to show to the Year 6 children that were coming back to school, to show them physically what would happen when they get to school. So where they would have to walk, they would have to be scanned at particular points in time, walking them around the building, showing them what would happen at lunchtime. And I appreciate that's not a work environment, but actually I think it's really important and something that can be translated into the workplace. Partly for the to reassure people that you've put in place measures, but also actually from a health and safety perspective. For many people, the way in which employees will be coming into the building or moving around the building will change. And the more that you can ensure that people visually know that in advance, the less the risk that you're going to get larger numbers of employees bunching together, which of course is going to be hugely problematic from a social distancing perspective. So hats off to my daughter's school. I thought that was very effective. Sadly, my daughter's not in Year 6, so she's not going back. There are obviously other steps that you should be taking. For those of you that have read the government workplace guidelines, you will have seen that there is a requirement to obviously carry out a COVID risk assessment, and yet they said that we expect that employers of 50 or more employees will publish that on their website. And they also have stated that you should be in the workplace guidelines there's a one-page printout which is essentially talks about the 5 key steps for compliance with health and safety obligations, and saying that you should be printing that out and putting that on the wall in your workplace. So obviously you should be displaying that as well. So sharing the risk assessment. The workplace guidelines document was a really interesting one. There's been many statements made at various points in time by the various different government organisations, which aren't quite consistent with the law. And the workplace guidelines was a classic example of this, because plastered all over this document was a statement that employers must consult with the health and safety representatives selected by a recognised trade union, or if there isn't one, a representative chosen by workers. So saying essentially you have to elect, if you don't have your own existing health and safety representative, employees should be electing one. Now that isn't actually what the relevant law says. The relevant law, which is in a non-unionised environment, the health and safety consultation with employees regulations, says that you should consult with elected health and safety representatives if they exist, but if not, you can consult with your workforce directly. There's no requirement to elect a health and safety rep if you don't want to. And I know from speaking to many of my clients that they feel that that is too onerous an obligation. And actually, what's really important is having, one-to-one dialogue with employees. So you can take a view on that. Obviously, you won't be criticised for electing reps, and I know that certain clients are. But I think the key thing here is making sure that employees understand what you're doing, and it goes back to this kind of communication and psychological piece, which is the more that you can share with employees what you're doing and ask them for their feedback, the more reassured they are that they will be safe at work, and the more likely it is that they will come back to work, which obviously is what the government ultimately wants. So a number of our clients are putting together initial plans, identifying risk areas, sharing that with employees and asking them for their feedback. Now, it's up to you the extent of the detail that you provide. But I would say this, that actually it's very, the kind of level of detail that people need to be thinking about here is quite considerable, and it's very likely that your employees will think of areas that you haven't thought of just from walking around the buildings. So I would encourage you to think about ways of communicating with staff and what your plans are, and asking them for their feedback. Obviously, if people are really struggling from a mental health perspective, psychologically, with the concept of coming back to work, if you have EAP programs, then that can also be a useful area of support that you may want to direct employees to. So that's the kind of more practical side of things. Just moving on then to the kind of more legal aspect of this. Ultimately, if an employee refuses to return to work, then technically you're looking at an unauthorised absence from work, which in an ordinary world, we haven't operated in an ordinary world for many months now, would be a disciplinary issue which could entitle you to dismiss. And there is still that ability, if you think it's reasonable to do so, to move to potentially dismissing somebody if they refuse to come to work. You could potentially consider unpaid leave as a precursor to that. I think that's probably a slightly more cautious approach. The area of law that we need to be mindful of here is sections 44 and 100 of the Employment Rights Act, which I have to confess, before COVID, I never had to advise on. I think it's more common in a manufacturing environment, but in my client base, it wasn't really anything that came up, but it's absolutely relevant here. Now, what these provisions do is they protect employees against detriment and dismissal as a result of the employee taking steps to protect themselves or others in circumstances of danger which the employee reasonably believes to be serious and imminent, and which the employee could not reasonably be expected to avert, and in those circumstances he left or refused to return to his place of work. So the example here would be, I believe that by coming into work I would be at serious and imminent risk of harm from catching coronavirus, and therefore I'm refusing to come to work. None of us can dispute the fact that there is potential that these employees may well believe that they are at serious and imminent danger from COVID, irrespective of the fact that the infection rates are dropping. We know, many people will be worried about this. Their ability, an employee's ability to rely on sections 44 and 100 depends upon whether or not the belief that they hold is reasonable. And here, the key issue is what the employee knows about the steps you have put in place to protect their health and safety, which is why the communications piece that I just talked about is so incredibly critical. Because you could have put in the most amazing steps, but if you haven't told your employees about them, then you're really going to be in trouble in terms of an employee bringing in claim under section 44 or 100. So key point one, communicate. It's obviously also incredibly important that you ensure that you have followed the government workplace guidelines. So if you haven't read those workplace guidelines for your sector, I would very, very strongly encourage you to do so, because the more that an employee can point to parts of those guidelines that you haven't put in place, the easier it will be for them to say that it was reasonable for me, the employee, to believe that I was at serious and imminent risk of harm if I came to work. Just to flag that your obligation is not to eliminate all risk. You cannot possibly eliminate totally the risk of somebody catching coronavirus. All you can, the expectation is that you will do all that you can to reduce it to the lowest reasonably practical level. So if after having made employees aware of all of this and spoken to them and tried to convince them that they will be as safe as is reasonably practicable, they're still refusing to come into work, at that point you will be going through a consultation process, potentially you can phrase it as you wish, disciplinary, and look at suspending pay or ultimately dismissing after that if they still refuse to come back to work. So just one to be mindful of. So moving on then, you then have the class of people who say, well, actually, do you know what? I really like working from home. I want to do this on a permanent basis. Clearly, they haven't spent time with my children, but each their own. Undoubtedly, I remember the very last face-to-face seminar that I gave before we went into lockdown, which I think actually was a joint Michael Page event. COVID was just was brewing, and I remember saying that I anticipate that this is going to create huge changes in the way in which we work, and working from home was obviously one of the issues that we flagged, and for once I was proved right. We are expecting a very, very significant rise in the number of flexible working requests, people working either permanently or for a portion of their time at home. And it is likely to be harder for many employers to argue that home working doesn't work. Certainly over the years I've advised on a number of home working requests where the manager has just said, no, it won't work, can't work, I'm not going to agree to it. Well, for a lot of businesses, home working has worked. It may not have worked perfectly, but it hasn't been the kind of catastrophe that some of the managers have said in the past. And employees will undoubtedly refer to that to support applications to work from home. So, the usual obligations in relation to flexible working requests will still apply. You should be meeting with them, unless you're happy just to agree to the request. And you should be meeting with them. That meeting, they have the right to be accompanied. If you refuse the request, you've got to point to one of the 8 lawful reasons for refusing, and you should be offering a right of appeal. If you are going to agree to a home working, to a change to home working, it's really important that you document that carefully. I think, whilst people have been working from home during the crisis, it's been a bit more fluid. But certainly if you've agreed to a permanent change, whether that be permanently at home or 3-4 days a week at home, you need to make sure that contracts are amended to reflect that, not just in terms of the change in location of work, but also that there are other provisions that you need to be thinking about addressing. So, for example, allowing the right to enter a person's place of work, a person's home, to be able to retrieve your property, including provisions requiring them to visit the office if necessary. You may want to think about including a trial period. There'd have to be a reason for that at the moment. And separately, you should be producing some kind of home working policy which sets out expectations in relation to costs. We're very commonly asked, do we need to pay to allow people, the costs for people to work from home? There's no obligation to do that. And one argument that we're very commonly seeing at the moment is, well, what you're incurring cost-wise in terms of gas and electricity is more than covered by the savings that you're making in terms of commuting costs. So make sure that you're making clear what will and won't be covered. The other thing to bear in mind is that we've been in somewhat of a holding pattern in relation to health and safety for home working. So if you just go back to the previous slide, and the health and safety executive has understood that that employers, that it's not going to be practical. It wasn't practical when the crisis hit to do large-scale risk assessments, and that the working from home was a temporary arrangement. Your obligations will change once it becomes a more permanent arrangement, and you're going to need to be ensuring that you're carrying out much more full risk assessments. So moving on then, I'll just very briefly touch on the issue of the changes to the furlough scheme, which I'm sure you will have all seen. As of the 1st of August, the cost that employers are going to incur in relation to the scheme are going to increase. So from the 1st of August, employers are going to have to pay the employers' NICs and pension contributions. And then in September, it will be that plus 10% of wage. October, it will be 20% of wage. The increasing costs for some of our clients are going to make this scheme unaffordable. And I'll come on in a minute to the issue of what that means in terms of difficult decisions. The government announcement of last week has made it clear that the scheme is going to be closed to new entrants as of the 1st of July. In order for somebody to be claimed for, apart from obviously the people on family-friendly leave, they had to have been furloughed by today. Today was the cut-off point. They had to have started today. So if you haven't got somebody who's been on furlough for by now, then unfortunately you won't be able to claim for them. One other important point is the government produced a fact sheet, which some people may not have seen, in which they said that going forward from the 1st of July, the number of employees an employer can claim for in any claim period cannot exceed the maximum number claimed for under any previous claim under the scheme. So If you, in previous months, the maximum number of people you've claimed for on any one time is 50 people, you won't be able to claim for more than 50 people any one month going forward. So moving on then, obviously the other big change that's coming into force from the 1st of July is flexible furlough. As of the 1st of July, employers will be able to bring back furloughed staff for any amount of time. So you could have, say, 2 days furlough, 3 days working per week. You'll still be able to claim under the scheme for the furloughed days, but you're going to need to pay employees their normal pay for the days when they're working. I mentioned there about if you're keeping people on furlough but bringing other people back flexibly who are carrying out the same jobs, again, it's important you're able to justify and evidence those decisions. The government has said that the new arrangements need to be agreed with employees, and then that agreement must be confirmed in writing. They're going to be issuing further guidance on that, we think, this Friday, so watch this space. But one really critical point I just wanted to flag about the flexible furlough scheme is you are going to be required, if you're using the scheme, to report the number of hours worked and the number of hours an employee would normally work in a claim period. So recording hours is going to be crucial. It's very, very important that you make it absolutely clear to your employees they must record the hours that they're working, and you give them a very clear instruction that they shouldn't be working more than the hours that you've agreed with them. So moving on then, I talked about the fact that costs are going to be increasing with the furlough scheme, and unfortunately that does very much mean that many of my clients certainly are now looking at the issue as to whether it is the time to start considering right-sizing their businesses and effectively making redundancies. There has already been a cost associated with the furlough scheme in terms of holiday accrual, but as I said, the amount of the costs are going to increase, quite considerably by October. The government guidance has confirmed that employers can make employees redundant when they're on furlough leave, and it follows from that you can also consult with employees when they're on furlough leave. And if you're looking at a collective redundancy situation where you're looking at dismissing 20 or even 100 more employees at any one establishment in a 90-day period, as I'm sure you'll know, there's an obligation to collectively consult for 30 or 45 days. If you hold off until after the furlough scheme has ended, there will then be that 30 plus 45-day period during which you have to carry the full salary costs. If you carry out consultation during the furlough period, those costs will effectively be subsidised by the furlough pay. It's obviously a difficult process to go through, and employees are certainly saying, well, why can't you wait until the end of furlough? But the reality is you are allowed to do it, and it will allow for savings. So if you're not already doing so, you should think about that. Another point I just wanted to flag was in relation to notice pay, where notice is given during furlough, having gone through a consultation. There is a quirky provision of the Employment Rights Act, section 87 to 1889, the effect of which is that if someone's contractual notice period is at least 1 week more than their statutory minimum notice period, then you can simply pay furlough pay for the amount of the notice period that falls during the furlough period. Conversely, if someone's contractual notice period is less than 1 week more than the statutory minimum notice period, you will be required to pay full salary during the notice period. Now, as I said, this is quite a quirky provision, and I have a number of clients who are aware of it but have decided that actually, irrespective of it, they're going to simply pay full salary through the notice period. But I also have some other clients who are in very serious financial situation and are going to be relying on this provision. It's a bit of a complicated one to get your head around, but it's best seen by an example. So if you have an employee with 4 years service, they're entitled from a statutory perspective to 4 weeks notice, but their contract gives them 3 months notice. The 3-month contractual notice period is at least 1 week more than their 4-week statutory minimum notice period. And in that circumstance, you can pay just the furlough pay during the notice period if it falls within the furlough period. One final point on redundancy and furlough. Furloughed employees can be elected representatives representing employees without compromising their furlough status. However, what you can't have is furloughed employees carrying out the consultation on behalf of the company, because they are they're carrying out duties for the benefit of their employer. So if you need managers to be carrying out a consultation process on your behalf, you're going to have to bring them back off furlough. So two final kind of points for me to talk about here, and they both relate to the issue of kind of annual leave and travel. So if we just move on to the next slide, the annual leave backlog has been a massive headache, and we had to wait a very long time for the government to clarify the position in relation to annual leave and furlough. We got that clarity a few weeks ago, and the government clarified that holiday accrues during furlough, and it can also be taken whilst on furlough, and crucially that employers can require employees to take holiday whilst on furlough. The challenge we've got is large numbers of employees, both on and off furlough, that are not taking holiday because of the travel ban, and because, well, why would I take holiday? I'm stuck at home. This is creating a huge financial exposure because it's constantly accruing, and operational challenges. You know, we come out of lockdown and suddenly everybody wants to take holiday. Employees' expectations have been somewhat, you know, incorrectly lifted by the amendment to the working time regs that was released very early on, when the government announced that employees will be able to carry forward up to 4 weeks paid holiday over a 2-year period if it wasn't reasonably practicable for a worker to take holiday. And I've certainly seen employees saying, well, okay, well, I can't take holiday because we're in lockdown and therefore I can carry it over. But that's not actually correct. And the circumstances in which it will be deemed not reasonably practical to take holiday are very, very limited. So for example, when we received the guidance from the government on holiday and annual leave and furlough, they said that that being on furlough, for example, doesn't normally mean that it won't be reasonably practical to take holiday. But they gave the kind of examples they gave where it would be deemed not reasonably practical are, for example, if a business has faced such increased demand that it's been sort of all hands to the deck and you need all of your staff there the whole time, and you couldn't allow them to take holiday. If an employee couldn't take holiday because they've been extremely ill. So it is really those kind of exceptional circumstances. And certainly, you know, for most of my clients who were previously office-based and have just got all staff working from home, many of them are taking the approach that, you know, this rollover provision just doesn't apply to you unless there's exceptional circumstances. There are clearly financial advantages for getting employees to take holiday whilst they're on furlough. Whilst the holiday pay itself will need to be paid out at the full salary rate, but it will again be subsidised by the furlough pay. And crucially, as I said, you can require employees to take holiday during furlough. The government guidance sort of threw in this line that says employer should consider whether any restrictions the worker is under, such as the need to socially distance or self-isolate, would prevent the worker from resting, relaxing and enjoying leisure time. Well, now all of us are having to socially distance and some of us are having to self-isolate, but our view is that as long as you can show that you considered whether any of the restrictions would prevent an employee from taking holiday, and in most cases it won't, then you've dealt with your obligations there. And again, in terms of requiring employees to take holiday, you go back to the position under the working time regulations, which says that you just need to give employees double the amount of notice as the length of the holiday. So for example, if you're saying to them, you have to take a week's holiday, you need to give them 2 weeks notice. So final point from me, what do we do about employees who want to travel abroad? As of Monday, we know that travellers arriving in or back into the UK are required to self-isolate for 14 days, apart from some limited exceptions. The concern is that come July, August, if this is still in force, this quarantine period, and I question that, I think we may see an unravelling of it quite quickly. You know, what do you do if employees go abroad or want to go abroad and then come back and can't work from home and so they can't work? Well, you can't prevent an employee from travelling abroad, that's their right. And as it currently stands, you don't really need to even know where they're going abroad because this quarantine applies to everywhere. But what you can do is make sure that all employees are aware of the potential implications for their pay if they do go abroad. Because if an employee can't work when they come back, currently it doesn't look like they'll be eligible for statutory sick pay. And therefore you could take the view, well, you can't work, you've voluntarily chosen to put yourself in a position that you can't work, so we're not going to pay you for it. You could, as an alternative, say, if you want, you could take some more annual leave to cover that time. But I think it's very important that you do that as a preemptive step. You don't wait until after an employee goes, or indeed after they've booked, if possible. So you may want to consider putting out some kind of policies now on how to issue on this issue and how you're going to be approaching it, understanding that you may need to have some flexibility, for example, for people who've suffered an overseas family bereavement. So that was my section. I'm going to hand over now to my partner, Supinder Sian, who's going to briefly talk through some of the business immigration issues that are coming up because of the coronavirus pandemic. Thank you.
Thanks, Miriam. That was seamless. We could have been in the same room. So just as Miriam did, I just wanted to kick off with a quick poll to see your appetites for international travel. So when will you be resuming business travel and your international assignments? So sending your staff overseas or looking to bring colleagues or new hires from overseas to the UK under the points-based system. So between now and the end of August 2020, between September and December 2020, or in 2021, or you have no idea yet. So I'll give you sort of 30 seconds to answer those, which will be great. Okay, thank you for everybody. So, surprising. So 58% of you on the call today are uncertain when they're likely to resume. As I'd expect, not many people looking to make any trips now and August, but looking to start increasing that toward the end of the year, and hopefully things get back to some form of normality in 2021. So thank you very much for that. That's some interesting data. Luke, if we just move to the next slide, please. Thanks. So I just want to take a few minutes just to bring you up to speed on the COVID-19 disruption and how it's impacted business immigration in the UK. So just to finish off what Miriam started, the quarantine, it started Monday gone, so on the 8th of June, and it will be reviewed every 3 weeks. Now, there's a lot of opposition to the quarantine rule, some saying it's way too late, some saying it's going to impact the economy even further. So hopefully this is going to be a short-lived requirement that will be reviewed in 3 weeks, relaxed, maybe even dropped. Spot checks will take place, and that is important. So not every single person that's coming into the UK is going to be checked by a health professional, and whether they've answered their question or even quarantining properly. And to police that, there will be fines. So if somebody fails to complete an application form on arrival in the UK, specifying where they've come from, where they'll be staying in the UK, and whether they're in an exempt category or not, they could get a £100 fine. If they then fail to self-isolate where they're required to, it's a £1,000 fine. And for repeat offenders, the government could bring around criminal prosecutions and/or unlimited fines, for those persistent offenders. So that's sort of the quarantining rules. Do reach out if you have any questions in the chat facility about any of the exemptions. One thing to note is if you have any frontier workers or cross-border workers, to those that live in the UK but are required to travel to your overseas offices at least once a week, they will be exempt from quarantining on return to the UK. There is a long list of exemptions if you do want to read that. So specifically with regards to UK immigration, if you had an employee who was sponsored or had a visa and working for you and their visa had expired or is set to expire before the 31st of July 2020, the Home Office is extending those visas. The individual does need to email the COVID immigration helpline and they'll be granted a gratis extension of that permission to the 31st of July. Now that could be extended further, but as we saw in May, because the first extension was due to expire at the end of May, they only gave people a week's notice of the extension, so it could be quite late into July before we hear if that extension is going to move to the end of August. Now, quite an interesting concession from the Home Office is to allow in-country switching. So again, where you have individuals in the UK, they may be on a Tier 5 Youth Mobility visa, and you wish to sponsor them under the Tier 2 points-based system, they would normally need to leave the UK, return to their country of nationality and apply for a visa to come back to the UK. If their visa expires before the 31st of July 2020, they'll be exceptionally allowed to make that application from within the UK, but the same qualifying and eligibility requirements will apply. So that is very beneficial if you do have Tier 5 youth mobility workers and you are looking to sponsor them. Now, visa application processing has all been outsourced to third parties. So in the UK, a company called Soprasteria handle it on behalf of the Home Office, and outside of the UK, it's run by companies like VFS and TLS. Once the lockdown started, they all shut down and stopped receiving any new applications and held on to applications that were pending and subsequently cancelled. They have started to reopen, some earlier this month, and another tranche is set to reopen on the 22nd of June. So do look out for openings if it help any of your colleagues overseas with pending visa applications. Inside the UK, the application centres have resumed operation on a limited capacity, but will only be looking at those that had their applications cancelled. And once they've managed to catch up with the backlog, they may start accepting new visa applications, which is causing a real delay on some forms of in-country applications, particularly where you're trying to undertake what's called a change of employment application, where you're moving one sponsored individual to yourselves, having sponsored them. The other issue, which is pretty problematic around our clients, is where somebody has got their visa from overseas. Under normal circumstances, they'll be given a 30-day entry permit. They haven't been able to travel, so that 30-day entry permit has expired. To counter that, once the application centres have reopened overseas fully, they will be able to contact their local application centre and have a new entry permit re-endorsed, and that will be free until the end of this year. But it does require them to go back to the application centre when they reopen, and may have to give up their passport for a further period of time for re-endorsement. Now, shortly after the furloughing system was announced, the Home Office agreed to allow sponsors to reduce the salary of their sponsored workers in the UK if it was to help avoid redundancies within their business. So it's not called furlough, they're just allowing these reductions, but they must be temporary, and sponsors are allowed to reduce salary to 80% of the sponsored salary or £2,500 a month, whichever is the lower. And if you do reduce a sponsored employee's salary, you must report that change via the sponsor management system. And when they go back to their pre-reduction levels, again, that has to be reported in order for you to continue to comply with your sponsor compliance obligations. Now, other SMS updates have been waived for sponsors. So, for example, where your sponsored workers are now working from home, be that in the UK, they've returned home overseas, we do not need to update the Home Office of their work location, provided it is temporary and they are still doing the job for which they are sponsored. And you as the sponsor continue to comply with your sponsor obligations by having up-to-date contact details and checking in with them on a time-to-time basis. Right to work check. Okay. Under normal circumstances, an employer would need to check an individual's right to work in the UK by asking for a copy of their passport and or visa or biometric residence permit. Now, the employer would need to see the original document, take a copy, sign and date that copy, and retain that information on file. Because of social distancing and COVID, the Home Office have temporarily allowed those right to work checks to be undertaken through video calls. But once it's safe to do so, you will be required to request the original documents from that employee to take the correct copy. So again, certified copies of the document to retain on file in order to retain your statutory excuse. Now, as we continue to unlock the lockdown, and I'm sorry to bring it up, but I'm going to say the B word, Brexit. So it looks like that the end of the transition period is going to be at the end of this year. So we go into 2021 with a new immigration system and EU EEA nationals subject to UK immigration rules if they are not resident in the UK by the 31st December 2020. So from a recruitment perspective, looking into next year, if you haven't got a sponsor license already, you are likely to need one if you want to bring migrants in from the EU, the EEA. If you do have one already, expect a new points-based system coming into force on the 1st of January 2021, which you will now use for any new migration from the EEA. And for your existing EEA national staff, do remember they need to have registered under the EU settlement scheme by the end of June 2021 on the basis they are resident in the UK by the end of this year. That's a very quick run through of the immigration disruption COVID has brought around. And I will pass you back to Luke and address any questions you may have had. Thank you.
Thank you, Miriam and Supinder. I know it must be very difficult to summarise some really challenging subjects and quite a
Oh.
Luke's gone.
We appear to have lost Luke, so I might just jump in at this point. We had a couple of questions that I will go through some of them. So we've had quite a few, but and I'm conscious of coming near to the end of the webinar. So we've had one question is, if I made an employee redundant, can I claim back the 80% through the furlough scheme? You can't claim your statutory redundancy pay back, but if you have somebody on furlough and you give them notice whilst they're on furlough, then their notice pay will be effectively subsidised by the furlough pay. But the statutory redundancy pay is your payment to bear, as is any holiday pay that is paid out on termination. That wouldn't be subsidised by the furlough pay. Luke, are you back? We lost you. Hello? Okay. No, still can't hear him. Okay, well, I'm going to carry on then. Luke, we can't hear you. Sorry, don't worry. Another question we had is, what is the recommended consultation period for making under 20 redundancies? People quite often think that there's a figure of 30 days. There isn't. It's as long as it's reasonable to address all of the issues that are necessary. In some cases, consultation, there isn't much to talk about. You can get it through it within a week or so. But generally, you're looking at 2, 3, 4 weeks, something like that. Luke, try again. Let's see if we can hear you. No, you still can't. No, you're still silent, Luke. Okay,
Well,
so another. Oh, hello.
No, just us two now. I think I can still hear you, Miriam. So
right, hello. Sorry, are we still online? I think we seem to be having some technical problems, so maybe the time is now to wrap up. I apologise for that. We're conscious that lots of people ask questions. We will, if we haven't addressed them in this webinar, we will get back to you afterwards and follow up with the questions that you've asked. There are, if you just move through on the slides and the recording, as I understand, will be sent round afterwards by the wonderful team from Page Group. On them, you'll see that there are some links there to our blogs that we're running and alerts that we're sending out on coronavirus. So do sign up for those if you're interested. I'm going to give it one last shot and hope that Luke can hear us. Luke, can you speak? No, okay. We still can't hear you. Well, apologies everybody for technical problems. This is the joy of lockdown and coronavirus time. On the plus side, none of my children walked in during this webinar, which is good. So thank you very much. That's the links to the various alerts that we mentioned. Thank you for joining. Sorry about the technology, but we hope you found it useful. If you have any questions, please do get in contact with us. So thank you from me. Thank you from Supinder. Thank you on behalf of Luke and from all of the teams at Michael Page and at Squire Patton Boggs. Thank you very much.